welcome. I appreciate you all coming here on the last panel of the day, although I suspect that you might just be trying to locate yourself closer to the bars when they open up at 4 o'clock. I think one opens up right over here. So we appreciate you coming. So you've heard Kevin's and my background. Not too many lawyers practicing lawyers I should say, come to the GEOINT conference, and I thought the symposium, and I thought I was the only one, but my very first symposium, which was several years ago, I've been with NGA, as you heard, about 10 years now. I sat down at lunch. I didn't know anybody, really. And Kevin sat next to me, and we just started talking. We didn't know each other and found out it's a fellow lawyer. And we have been partners ever since. And you'll hear at the end of our presentation today, or discussion today, some of the future we have at USGIF. That's something we envisioned and talked about our very first year that we met. So we appreciate USGIF giving us this opportunity for you to hear from us, the lawyers, to highlight some legal issues. I won't call them challenges. Mr. Deloche just called them opportunities, and they really are, that really impact the business of GEOINT. And that's why we're going to sort of highlight those for you today. So we're going to basically just give you a quick lay of the legal land, as I like to call it, from the perspective of the lawyers. So Kevin?
Thank you, Cindy, and thank everyone for coming. A lot of times the legal panel is at the end of the day, as Cindy suggested, and so we appreciate the extra work involved as you're thinking about other things you could be doing. I've got some slides. I'm not sure if how to go about. If we could have the next slide. Is there?
There you go.
Yeah. So I'm just going to highlight some of the perspectives that I have. I've been practicing law for more years than I care to discuss, but I've been involved. My first job out of undergrad was as a satellite imagery analyst with NPIC, which was a predecessor to NGA. So I've been involved in the geospatial community for a number of years. And some of the things that I've sort of seen evolve, one of the most important things is the development of this geospatial ecosystem, where traditionally data would go one way. There'd be a data provider and a data user, and often it was government to industry or industry to government. But over the past several years, we're seeing this ecosystem develop where you have government, you have industry, and you have what we generally refer to as the crowd, which is citizens, but it could be academics, NGOs, everyone else that's collecting information. And the unique aspect of this is if everyone is becoming both a data provider and a data user, and often simultaneously. And that's got business challenges associated with it. It's got business opportunities as well. From a legal and policy standpoint, the challenge is if you insert a law to protect one aspect of that, you're likely to impact the others. So if you insert to try to protect the collection of data that you consider of an individual for privacy purposes, you're interrupting that flow of information. Or if you're a government and you're not sharing information because of concerns, you're interrupting that flow. So that's one aspect of this ecosystem, and from a legal standpoint, that I think are going to be interesting to follow, and some of the challenges that lawyers in this space will have as they try to understand that. Next slide, please. The other sort of high-level issue I wanted to talk about is something I refer to as the location privacy paradox. So here's a picture taken in 2005 in St. Peter's Square in connection of the death of the Pope at that time. And you can see a number of people just looking and waiting for a convoy to come by, and no one's thinking about privacy from that standpoint, right? They're just sitting there waiting, or standing there, excuse me. If you can go to the next slide, please. This is just 8 years later, all right? What happened in the 8 years was the iPhone, and then the tablet, and smartphones, and camera-based phones, and Twitter, and Facebook, and all these technologies that people are now not just standing there now, they're collecting and they're sharing information about themselves and everyone around them, right? I mean, this is a major change. At the same time, they're more concerned about their privacy than ever. Their expectation of privacy is changing, particularly with respect to location. Who knows where I am? Even though they're sharing where they are, they're concerned about where they are. And the lawmakers and the policymakers are reacting to that, and they're feeling pressure with these new technologies to introduce new laws and policies. And I think in particular for this community, old ways of doing business are going to change because of this privacy paradox, because of the way the new technologies are. And unfortunately, there's going to be this period of uncertainty because the legal and policy communities are reactive, and they're not sort of able to move as quickly as the technology. So 5 years from now, we can have another slide here. It's going to be totally different. It's going to have a whole other set of privacy implications, but that's the legal challenge that lawyers are facing within organizations in this community. Next slide, please. So many of you probably have seen this slide in different forms regarding how different geospatial products and services are developed, or the different layers of data that are included in each one. And you look at this and you're fascinated about what you can do with this. As a lawyer, and I think Cindy would agree with this, what I see are 1, 2, 3, 4, 5, at least 6 different license agreements involved there. If you've got different data suppliers that are giving this, and you need to conform all of those to make sure that the end product or service that you want to use, you can do in conformance with all the different licenses that you brought that in. So from a technology standpoint, this is great. And you look at the 3D models that are done here and some of the other virtual technologies that are being developed, fantastic work, but they're all bringing in data. And if you go back to that ecosystem I talk about, some are coming from government, some are from industry, some are from proprietary sources, and it's a real difficult thing. And people like to say, it's my lawyer slowing things down. That may be the case. I mean, I don't like talking to lawyers any more than any of you do, but the reality is it's the law that's slowing it down, not necessarily the lawyers. Now, I will tell you that part of the challenge is that many lawyers don't understand this technology. They don't understand the consumers. They don't understand where it's going. So it's easier for them to say no than yes, and that's just human nature. So part of your challenge in this community, I think, is to help get your lawyers to yes by explaining some of what you're trying to do so that they can help think through what the potential implications are. And the next slide, please. So as a lawyer, I speak at a lot of technical meetings, a lot of programs, and people get tired of listening to the legal stuff. So I decided to try to put my words into a formula. I thought for some people that would probably help. And what this formula tried to do is, again, address the complexity of bringing together different license agreements from different parts of the world with different jurisdictions involved, legal jurisdictions, because ironically, the laws is still one place where where laws are still tied to geographic regions. So I can do things here in DC that I can't do in Virginia. In fact, I can do a lot of things here in DC that I can't do in Virginia, right? It's tied to a geographic region. So if you look at this formula, what it's saying is that the complexity of trying to aggregate a variety of data sets is based on the number of different data sets involved, the number of different legal systems involved. So if it's from the United States and maybe from the state of Michigan and from France, perhaps, and then the number of parties removed from the original source. So you have licenses, you have sub-licenses, all of which your legal counsel has to consider when you're developing products and services that you're releasing into the market. And again, that's partly your lawyer, but that's partly the way the law is, and other industries are dealing with this as well, particularly the software industry. So those are just sort of a high-level view of my perspective of the community and some of the issues that are involved, and I think Cindy's going to talk about it from her perspective.
Thanks, Kevin. So really, how many here has a Juris Doctor degree? Just a few. But that's great to have a few colleagues, and thanks for coming. Really one of the things we're trying to accomplish here in a few minutes is the fact that to sensitize the non-lawyers about the legal issues that are out there and how much they impact your business and trying to get your business done. And lawyers really try to facilitate you getting there, but we have to deal with the laws as they're given us. And sometimes also the point is to educate fellow lawyers about saying you really need to understand your client's business and your customer's business so that you can help them and identify those legal issues early on, because it's much easier to deal with a legal issue early on as you're in the conceptual stage than it does at the end when you have to do it in the fix-it stage, and then you don't like us very much because we're like bringing bad news when you're so excited about the product that you've done. So that's why it's really a partnership, and we're just trying to sensitize you to that. So who heard Mr. Cardillo's keynote speech yesterday? Good, most of you. So do you remember in the Q&A section, he talked about, he said he had the best lawyers and contracting officers in the federal government. You remember that part? I do. I obviously do. But what he was talking about was in the Ebola crisis response context. And he had talked about the Ebola and the response, as well as the Nepal earthquake response, crisis response that NGA did. in his middle of his speech, but then he did a little bit on the Q&A. If you remember in the Q&A part, you heard, they said, well, what was the biggest challenge about that? And he says, well, you know, he said, we are going to put this out on the www, and we're going to put that in the public website, and you're going to do it now. That's what he told the agency to do. We all went, you know, some people went, yo, let's go. And the lawyers went, oh my gosh, right? Very different. So I thought to highlight some of the legal issues that he had to face. Remember him saying, he says, well, I was given a list of all these things that I could not do. Really, we couldn't do right away. It took us some time to work through the Ebola crisis response to get through all the different issues we had to address. Some were legal, some were not legal. But I'm going to go through some of those legal ones just in real high level so that you can appreciate that. But we did work through them, and for Nepal, we had all our lessons learned, and we got up and running in 24 hours as opposed to a few weeks it took us for the Ebola. So really, the problem is in general, is that we're dealing with laws and a legal regime or licenses or contract terms that were developed and agreed to in the sort of the traditional way of doing business of GEOINT. Yet we're trying to apply them to a new paradigm in how we're doing GEOINT at NGA. So that's really the issue, is as we go forward and we make new contracts, we do new licensing agreements, we try to have the terms now to be far more open so we're not as restrictive, so we don't have to deal with these issues in the future. So if you remember, the Ebola crisis was, we had the Ebola epidemic in West Africa, and NGA wanted to provide online public access to unclassified GEOINT through a public-facing web portal. We anticipate our customers were not only going to be several federal government agencies, but the Red Cross, which is a non-federal agency, first responders, aid agencies like the Red Cross, and responding and affected foreign countries, and frankly, persons all around the world. So that's a big audience we had to look at. As a result, NGA posted over 495 data layers, 202 products, 68 apps, and 100% of NGA's unrestricted elevation data. Right? So my office, we look at this, we say, okay, what are our issues? The first thing is did we have the authority to actually do this? Normally we disseminate GEOINT to federal agencies, US federal agencies. And so that was an issue we had to deal with. We looked at and we said, okay, what's the national security objective? What is the purpose? We looked under our Title 10, our Title 50 authorities, that's our Department of Defense authorities, and our national security, intelligence, and national agency authorities in Title 50. And we did an evaluation. We said, yes, we can. Off to a good start. The next was our licenses. First, the source director had to identify, and the analysis director had to identify what data sources are we using. The data sources then would inform us because they were just bringing in data. First, they had to identify the data sources. The data sources had license agreements with them. Then we had to find the license agreements. Then we had to read the license agreements. I actually had 7 lawyers, and there's only 37 of us total for NGA worldwide. That's including my position as well, my deputies. We had contract lawyers, we had mission lawyers looking at this, and we had a whole team put together. And so we started looking at licenses and looking at the terms of use and saying, okay, so some of the, as I said, some of the terms were written for NGA in the past. We were now trying to use it for something we hadn't anticipated. So for example, one contract that we used was to assemble the best available geospatial information databases, but the problem is that it had a clause in it, a sentence in it that said, it is not the intent of the government to release this data into the public domain. So right there we had a problem with our aggregator. So we had to negotiate that. So we really need to highlight the use of uniform licensing terms would be helpful. Again, Kevin talked about the complexities of companies that we have. We have collectors, for example, like the new small stats we're trying to work with. We have data providers, we have aggregators, we have crowdsourcing, the data producers. So we have to look at terms across the board as well. Another issue we looked at was being able to use digital globe imagery under our enhanced view contract. Helpful there is the fact that we actually have a clause in our contract that allows for, in emergency situations, DG allows us to use to disseminate their imagery for a crisis response for 30 days. And so we have a protocol that we do, and that works very smoothly. We always have copyrights, and as I say, we try to inform people, just because you have open source doesn't mean you have open use. And so with we have copyright a lot in some open source, and we have to work through the copyright information. And often, NG8 can take copyrighted material if we're just going to use it for one product. Let's say quickly, State Department wants to get a product out to a foreign country. They want to publicize something. And we say, okay, well, for this one use, we can call it a fair use under the fair use doctrine under the copyright restrictions because it's a national security use. But when you're just going to post open source and it's copyrighted out on the World Wide Web, you've really gone beyond that. So that's a whole legal issue we're trying to deal with as an intelligence community right now, and how do we do that? So we had to work through the copyrighted material as well. The foreign sources, we needed foreign sources. NGA not only brings in imagery from our NTM, we bring it in from Digital Globe, small sats, but we also bring in foreign source data. But we work in a multinational world and in operations, but we have bilateral agreements, right? And so we're not allowed to share with other countries what agreements we have with other countries. So we had to work one country at a time in order to be able to get their permission to release their data, to add it to our data, to give us a picture of Liberia and Sierra Leone and all those other surrounding countries where we really were not very data rich. So that took some while to work through because their sense of timing was not exactly our sense of urgency. Then we always have the ubiquitous intelligence oversight considerations, and while we're dealing in the open space, we are also having to deal in the fact that we are an intelligence agency and we have intelligence oversight restrictions. And so we have to make sure we're collecting, retaining, and disseminating information for the proper use. We have to make sure we had to look at, are we collecting and posting domestic imagery, and have we done that in the proper protocols, and can we do that at all? Is there U.S. person-specific information in that, and that not only as to people, but that as it is people's property. So we had to work how the database was going to work. So those are really sort of the big, what we call the big rock issues, and I'll leave it at there. But this is just to sort of tell you that's why when we say it's really challenging, but it's really exciting a time for law because we have to be creative. You don't usually like your lawyers being that creative, but to be really innovative in trying to take existing law that we can't really change very much, but in application we have to find new ways to apply it, and that's what we're trying to do, and we hope to be working with all of you and your companies in making sure that we think about these things and how the data is really going to be used, and so that we can use it in the ways that we're all trying to achieve. So I guess what we're trying to tell you is by the slides and what we say is that in order to be able to operate in the GEOINT world or in any business world, you really need your technical people, you need the business side of it, and you really need your legal people. And I also add in there policy, but you also need your security people. It all comes together. We're all pieces of the same picture.
Yeah, just the one thing that I add is that oftentimes the lawyer is the last person involved, and there are a lot of reasons for that, cultural, institutional, but it's often useful to bring them in earlier rather than later to help shape the solution. I tell to people all the time, if you draft a license or an agreement and you give it to the lawyer and just plop it on his or her desk and say, I need this done by tomorrow, it's probably not going to be done tomorrow just for human nature, But also, they're just going to move it to the back, right? Because they don't have the ownership in it of people who have been actively involved. So it's helpful if you can do that. And in that regard, and Cindy can, I'll sort of just describe it, and then Cindy can tell you why we're trying to do this on the objectives. But through the work of USGIF, we are creating this legal working group of lawyers of member companies, and part of the reason for doing that is because we do see the increasing need to sort of understand within organizations what the legal issues are, and the hope is that we can then sort of create dialogue between the lawyers and some of the technical folks, the business folks as well, so that some of these questions can be addressed more quickly and early on as the products and services are developed. Because as Cindy said, people want it now, right? They want the Ebola map out there now. And people expect it in this technology thing, so we need to consider the legal issues up front if possible. So Cindy, maybe you can tell them a little bit about the objectives of the group.
So this is what Kevin and I envisioned some years back, and we've talked with USGIF and Jeff Harris this year, and we really have 3 objectives for it. It's the Geospatial Law Working Group under USGIF. Kevin, I'll be heading up and getting us started. 3 simple objectives. One is to educate other lawyers. We need to train ourselves, just like we do in any other legal field, is to train each other. And 2 is to train non-lawyers. It's to help educate non-lawyers. I do this at NGA anyway, and on other issues. It's just sort of, if we can inform you of what some of the legal issues are, then you can be cognizant of that while you're doing your job and thinking, yeah, I got to take care of that, or yes, that phraseology in this contract would work a little bit better and would help me in our business. And then 3 is develop a community of interest of lawyers, so that we can have a dialogue. Because if you have your lawyers wrangling, right, then it's not going to be hard for you to do business together. If your lawyers don't agree, and I don't mean like on every single little term, but I mean on the larger issues, and trying to help each other, saying, well, if you do this and this really affects me, in this part of the chain of the business. So for the team GEOINT, the lawyers are part of the team, and we're trying to make a team GEOINT of lawyers as well. So we thank you at least for your interest, and now we just for Q&As.
Okay, let's kick it off. This is for either or both of you. Are you developing or thinking about developing a policy for public use of GEOINT material for disasters and epidemics? Would this make legal complications less intrusive?
I would say, at a general matter, lawyers don't make policy. We make a point of giving legal advice, but we are not the policy makers. But I think we have to work with the policy makers on what is what is going to be the practice, what is going to be the protocol, and we contribute to that as a team.
The only thing I add is that in a lot of areas I see a push for policy, best practices, guidelines, and where they have a legal construct involved, it's a group like the legal working group that we're putting together can help sort of at least identify the issues so that the policymakers and the decision makers can decide what they want to do. And right now, a lot of times those decisions are being made in vacuums and are either not being done or being made in such a way that it doesn't facilitate the actual policies that they're trying to develop.
Okay, next up, this is for Kevin. You counseled us to communicate with our lawyers. What is the best medium for doing this? Is it white papers, spreadsheets, briefing slides?
I can tell you that spreadsheets is not a viable option unless you have a very unique lawyer. Personally, I tell people to take your lawyer out to lunch and to have this sort of informal discussion about what it is that you're trying to do, what your concerns are, who your customers are, and what you're doing. I mean, that's sort of the very basic step, because then when you come in the next time and you have an issue, they have a context to put it in, right? And then, again, putting aside the spreadsheet, a PowerPoint may or may not work, for some people. A white paper, if it's just a couple pages, might work. But I think the initial point is just developing the context and the relationships so that they understand what your driving business and technology concerns are.
Okay, Cindy, you're up next. So, based on your experience with the Ebola crisis in Nepal, how will that impact your position on new license agreements for data and services for initiatives like NextGen?
So it's hard to be really specific, but I think that we have to think about not the specific use of the data. It's going to be more assumed that the data is going to be shared openly. It's not going to be for this specific set of customers and this specific set of customers. It's going to have to be more open if it's going to be unclassified and dealing with unclassified material, and it's going to be particularly if it's going to be unclassified. I mean, in the Ebola situation, we wanted to get it out, but if that's what we anticipate how we're going to be using data, because we're going to be doing data across all domains, and you can tell we're focusing on being transparent and getting it out to the public in general, then they're going to have to be less restrictive.
Okay, and here's a follow-on to that one, and for both of you. As NGA moves into humanitarian operations, what are the legal implications and relationships with the lead federal agencies with authorities in that domain?
We still work with the lead federal agencies, and for those of you who don't know that, that's really the federal government agencies, and NJ normally, for example, when there's a hurricane response, then FEMA will ask for assistance from NGA. We've already getting geared up for that. We see the hurricane come. Hurricanes are a lot easier because we can see them coming, right? So we get geared up for that. So FEMA, we will work through FEMA. We will provide information through FEMA, and FEMA is the lead federal agency. In the case of the Ebola crisis, we really didn't have a lead federal agency in this case. The Army deployed, so we knew we had them to take care of. State Department needed information, but we also, NGOs needed information. So we also realized the first responders in the field, in the foreign field, is who were going to need this information, and we needed to get it to them fast. So that's why Mr. Cardello went that route, but that doesn't mean we always go that route. So we still work on, depending on the topic and depending on the needs, still work through the lead federal agencies.
Okay, if you guys still have more energy, we have more questions. Are you aware of an instance in which geospatially referenced human or SIGINT can be called GEOINT content?
Can you repeat the question?
Can you repeat that?
If you wish. Are you aware of an instance in which geospatially referenced human or SIGINT can be called GEOINT content?
The key part of that question was, can I recall a specific instance? No.
Okay.
There. No, I mean, I'm not quite sure. I mean, if I could really talk about a specific instance of that. But whoever asked the question, if you want to engage further, I'll be glad to see if I can help you.
So moving right along, does the NGA data become open data?
Well, I could give the legal answer, like, depends on the definition of open. But no, not, some of it does. Some of it does. But I'm not sure. I think that just depends on the application that we use. And some of that will be.
Yeah, there's a point I was going to make earlier, and I think it fits into the open data question. So there's a scene in Jurassic Park, in the first one, where Jeff Goldblum says that life has a way. And I think data kind of has a way, right? So you collect data for one purpose, but it can be used for a lot of different other purposes. And it finds that purpose because you have business development people or you have needs. And so when you're developing a license agreement and it's for one particular purpose, it quickly moves to another purpose, and it may not even be suited for that purpose, right? So as a lawyer, part of what we need to think about is, where is that way, and what are the concerns, and what are the issues that arise. With respect to the open data, and I think it sort of fits with that, is that there really, the people in the open data community would disagree with me, but there really isn't a strict definition of what open data is, and it sort of depends on the context and how you want to use it. And one of the challenges is that even if data is open, it's almost always subject to a license agreement, because it's not, except for some federal data that's why laws is supposed to be made without any restrictions. Someone still owns it, and so they have to license it. And those license agreements, open data license agreements, are often very different as well, and some are more open than others depending on who you talk to. So I don't think that changes Cindy's answer, but I did want to provide a little more context.
All right, we'll take one more question. Historically, the U.S. federal government produced a good deal of data in the public domain. Have we moved away from this as a community, given that most of the best geospatial data is now owned or licensed by commercial organizations? And what is the impact of this shift?
I'll let you answer that.
I don't think we've moved away from the fundamental principle about federal data being in the public domain, other than certain sectors that remain the same, whether it be for national security purposes or those that are protected for commercial purposes, or for proprietary commercial purposes or privacy purposes. So I think that fundamentally changes. That hasn't fundamentally changed, and if anything, it's probably becoming even. You see even more of it, primarily because organizations are not only trying to make it publicly available, but they're trying to put it in formats and accessible in ways that it makes it easier for people to use. Right. So it's in some ways it could be more open. I think what may be the trend we're referring to is simply that there are more organizations that are collecting data, and so the market is changing, and it goes back to the ecosystem that I mentioned in the first. Everyone is a data provider and a data user now. We're all, we're sitting right here. We're both collecting data and using data for all sorts of different purposes. So it doesn't change the nature of the government's role, except as a data provider. It just maybe changes as a data user, and what the legal implications associated with that are.
If we could have a round of applause, please, for our speakers.